Good morning. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Kishore versus Whitmer, 972 F3D 745, Court of Appeals, 6th Circuit, 2020. Friends, today we're going to go to Michigan and talk about third parties advancing their rights. So for those of you who find excitement in that, come with me. This case involved the party known as the Socialist Equality Party. Have any of you out there voted for the Socialist Equality Party? Let me know. I'd love to hear about your experiences voting for them. I've not voted for the Socialist Equality Party, but I would consider doing that in some time. I did vote for the Socialist Workers' Party once, so I'm definitely willing to vote for a socialist. So what happened here, friends? What happened here? Let's read from the record. It says, quote, Joseph Tanaru Kishore and Norissa Santa Cruz seek to have their names placed on the Michigan ballot as candidates for president and vice president, respectively, without complying with the state's ballot access laws. They contend that the ballot access requirements, as applied, are unconstitutionally burdensome under the First and 14th Amendments to the United States Constitution when enforced alongside with Michigan's orders restricting in-person gatherings during the COVID-19 pandemic. End quote. Once again, we see a ballot access case, and once again, we see our friends invoking the First Amendment and the 14th Amendment. I like to say we love the First Amendment here. Free Press Media Press Inc. has a mission to advance the First Amendment, and we also love to advance third parties. So few things in life are more beautiful than when you combine the First Amendment and third parties. The 14th Amendment rocks too, so we salute them for invoking that. What did the court think of this? They say, quote, in normal circumstances, Kishore and Santa Cruz would have to obtain at least 30,000 ballot signatures of registered voters. Michigan comp laws, with at least 100 signatures from registered voters in at least one-half of the 14th congressional districts in Michigan. Michigan comp laws. However, a district court in Michigan permanently enjoined the state from enforcing these signature requirements against independent candidates. The district court in Graveline ordered as an interim measure that the signature requirements for independent candidates be reduced to 12,000. End quote. 30,000, my friends. That sounds high. That would be quite the feat to meet that. 12,000 is high enough. 30,000. Wow. This course, the case talks about COVID-19 and how that affects things. They talk about the stay-at-home order the governor issued in that state and how that affects signature gathering. As they say, quote, Kishore and Santa Cruz contend that Michigan's response to the COVID-19 pandemic, namely the stay-at-home order first issued on March 23, 2020, renders the ballot access laws unconstitutional as applied to them because they were effectively prevented from obtaining signatures and thus the order imposed a severe burden on their First and 14th Amendment rights. We conclude in Shockey versus Whitmer that strict application of Michigan's ballot access laws to primary election candidates, when combined with the stay-at-home order, imposed a severe burden on constitutional rights. End quote. So far, in looking at these cases, I'm not seeing many victories for our side. In that case, they're talking about Shockey versus Whitmer. They do say they gave some concessions to our side. So that is something to celebrate. So do they find that reasoning persuasive here? Do you think they would? Do you think it's persuasive? Let's see what they said. They say, quote, the burdens in this case are material less than those in Shockey. Significantly, the timing for gathering signatures was different. We held that there was a severe burden because Michigan's stay-at-home order remained in effect through the deadline to submit ballot access petitions, effectively excluding all candidates who did not already satisfy the signature requirements and predicted a shutdown. But here, Kishore and Santa Cruz had the opportunity to gather signatures from January 18th to March 23rd, before the stay-at-home order went into effect, and then the renewed opportunity in early June when the order was lifted. Although these are not normal times, we still consider all opportunities these parties had to exercise their rights. End quote. Have you ever gathered signatures before? I did when I ran for office. Fortunately, it was nothing like 30,000. So it is a hassle, and I cannot imagine the hassle of getting 30,000. So do you think that the state was right to do this? I bet you don't, because you're a third-party fan listening to this podcast. But you might say, not everything our side says is right. So what do you think? They have a strong argument here in my book in regards to invoking the COVID-19 pandemic, because certainly that changes things in election campaigning. They say the following quote, "But plaintiffs were free to obtain signatures in person from the time they announced their campaign in January until the stay-at-home orders were issued on March 23rd, and they were free to gather signatures starting on June 1st when the orders were lifted. They made the conscious choice not to do so, although their decision was quite understandable. We cannot hold private citizens' decisions to stay home for their own safety against the state." End quote. They are talking about in this trial how the Socialist Equality Party decided to stop some of their campaigning because they didn't want their staff to get the virus. That is laudable, if you ask me. So good job for you people with the Socialist Equality Party. They also say in this case, quote, "To be sure, obtaining signatures might well be more difficult now than it would be in normal circumstances, but just because procuring signatures is now harder, largely because of a disease beyond the control of the state, doesn't mean that plaintiffs are excluded from the ballot." End quote. What do you think about that? Would you have viewed this differently if you were in their shoes? So ultimately they conclude the following, quote, "The judgment of the district court is affirmed." End quote. Alas, alas for our side. We didn't get a victory here, but they made a good effort, and they had a strong case. Unfortunately, the strong case wasn't enough, but still we salute them for fighting this fight. The ballot access case here can inspire us to keep fighting. So let's keep fighting, friends. Long live third parties. Goodbye.